Welcome and thank you for standing by. At this time, participants will be on a listen-only mode until the question and answer portion. If at that time you would like to ask a question, press star 1. Today's conference is also being recorded. If you have any objections, please disconnect at this time. And now I'd like to turn the call over to your host today, to Ms. Melissa Grosso. Ma'am, you may begin.
Great. Thank you so much. And welcome back, everyone, participating in the 201 series. We are winding down on the last couple weeks of our webinars. We're excited today to bring you a webinar on TAAs, MLAs, and distribution agreements. As I mentioned, we're winding down, so we have 3 additional webinars over the next couple weeks. One quick reminder, if folks, I know some folks had to miss a couple of the webinars over the last several months, we did send net recordings of those, so you should have copies of those. If for whatever reason you don't have a copy of the net replay, just let myself or Deborah Denhart know. You've been getting number of emails from Deborah. So let us know if you have not received the particular net replay for a particular webinar, and we'd be happy to send that out to you. Earlier on in our webinar series, you heard from one of today's speakers' colleagues, Tahlia Townsend, who provided an overview of BIS regulations. We're happy to have her colleague, Dana Stepnowski from Wiggin and Dana on the line today. And just to give a little bit of background, since Dana's a new presenter for us, Dana is a litigation associate at the firm's International Trade Compliance Practice Group in Washington, D.C. And prior to joining Wiggin and Dana, Dana was an associate at Paul Hastings, also in Washington, D.C., and was senior counsel for international trade compliance at United Technologies Corporation. Dana has extensive experience advising clients on export controls and economic sanctions compliance, and she's conducted internal investigations and has prepared voluntary disclosures related to potential violations of the ITAR, EAR, and OFAC regulations. So she has a plethora of experience, and we're happy to have her with us today. Dana, thank you so much for joining us.
Great. Thank you, Melissa. So obviously the focus of today's presentation is ITAR agreements. I think, we laid it out to give you a brief introduction of export law basics, although I think most of the people on the call have some familiarity with that already. So we'll go over that very quickly and move on. But the focus of today mostly will be providing you an overview of what ITAR agreements are, the types of activities that would require an ITAR agreement, the process for applying for an ITAR agreement with the Department of State, and then managing that agreement once you have it in place. And then we'll spend a little bit of time discussing some special situations and the impacts of export control reform, and then hopefully have some time left over to answer any questions or have a discussion on anything relevant to the presentation today. So I think one thing I want to say about the presentation here too is I've included a lot of detailed information throughout the slides, and primarily with the idea that this could be used as a reference document. I think something important to keep in mind with anything related to the ITAR, but also specifically with agreements, is that it's very, the requirements are very specific, and each situation requires you to look closely at both the regulations and the guidelines provided by the Department of State. And this can be a helpful tool in pointing you in the correct direction of where to start that research or inquiry. And that means that I won't necessarily reference every single line in the presentation or talk in detail about all of the subjects highlighted here. But, with regard to export laws in general, U.S. law, various agencies require government authorization for all exports and re-exports of controlled data, controlled goods, data, and services. And ITAR is one set of regulations that governs the export of controlled items and data and certain services related to military and defense. So here it just highlights that export is defined broadly. I think while you can look to the specific definitions, one thing to keep in mind is that any time a physical item or information that is controlled is transferred to another person outside of the United States or a non-U.S. person, you're potentially dealing with an export. Always, you know, that can be the shipment or transmission of specific hardware, or it can be the release of information just simply by showing that to a non-U.S. person, whether inside the United States or outside of the United States. And I think a theme throughout, again, anything related to dealing in ITAR goods, services, or technology is that the definitions are broad, and you need to be cognizant of those limitations and whether you're dealing in something that's controlled. So some examples of exports include foreign sales, exhibitions overseas, collaborations with foreign partners, research with foreign graduate students, providing physical or IT access to foreign employees, contractors, or IT service providers. Overseas travel can involve the export of controlled technology and hardware. Sending hardware overseas for repair, and even, as I mentioned before, storing data in the cloud or outsourcing IT services to foreign IT providers. So those are things to be always cognizant of when dealing in controlled technology. U.S. persons and foreign persons in the U.S., as well as foreign persons that are in possession of goods, data, or software that are subject to U.S. controls, and foreign companies owned or controlled by U.S. companies need to be aware of U.S. export controls and know that they are subject to the regulations that govern. And here's a definition of U.S. person, which I think most people are probably fairly familiar with. You know, U.S. citizen or lawful permanent resident or protected person, and also entities that are organized to do business in the United States, even if they're ultimately foreign owned. So the two primary agencies that regulate exports are the Department of Commerce, Bureau of Industry and Security, and the Department of State, Directorate of Defense Trade Controls, or DDTC, which obviously will be the agency that governs what we're discussing today. And we always note that there's other agencies that have some limited control over or regulatory control over exports. The biggest is OFAC with regard to economic sanctions, but also the NRC and the DOE have limited export authority as well. So we'll talk about ITAR agreements. You know, one thing to keep in mind is that agreement is just one form of export authorization that's available from the Department of State. There are other authorizations, such as licenses or exemptions, that may apply in certain circumstances and may even apply in relation to an agreement. But agreements are the authorization that are required for a U.S. person to provide defense services or to manufacture defense articles abroad, or to establish a distribution point abroad for defense articles of U.S. origin for subsequent distribution to foreign persons. So here's a definition of defense articles and defense services, which I won't read through, but again, keep in mind that all these definitions should be, you just keep in mind that they're very broad, and so they may incorporate things that you wouldn't necessarily intuitively think of as a defense article or a defense service. So it's always important to review the definitions in the context of what article or service you're dealing with. Here's some examples of activities that might require an ITAR agreement. Supporting direct commercial sales to foreign parties, providing overseas maintenance or training support, technical studies, evaluations, demonstrations, or consultations with foreign parties, release of manufacturing data or rights, efforts to import technology from abroad. And there's a couple other examples. I think, you know, one thing to keep in mind is that you're typically going to be looking for an ITAR agreement in circumstances where you're working on a project for, with a foreign party that involves providing technical data or defense services to that foreign party on a long-term basis. So here's the primary types of ITAR agreements: a manufacturing licensing agreement, a technical assistance agreement, and distribution agreements. There's also offshore procurement agreements, which are technically a license, although we've listed them here because they have similar characteristics to the other primary ITAR agreements. And this gives a little bit more detail about when those agreements are necessary. So an MLA is needed when you're manufacturing a defense article abroad that involves the export of technical data, defense articles, or the performance of a defense service, or the use by a foreign person of technical data or defense articles previously exported. And the TAA is when you have the performance of defense services or disclosure of technical data, which can be for the assembly of defense articles. And then a WDA, a warehouse distribution agreement, is when your business wants to establish a warehouse or distribution point abroad for defense articles to be exported from the U.S. and then subsequently distributed to other end users in approved territories. And then the offshore procurement agreement is when you're exporting unclassified technical data to foreign persons for the purposes of offshore procurement of defense articles. So here are some activities that do not require an ITAR agreement. Some basic training on basic operation and maintenance of defense articles, certain maintenance-related defense services to NATO countries, and then there are certain circumstances where DDTC will approve the provision of defense services by granting a license. So oftentimes will occur when the activity is limited in scope and duration, so it doesn't make sense to have a more fulsome agreement when it's for a limited purpose. So here, when we get into the details of applying for an ITAR agreement, one thing you'll notice specifically in the next few slides is there's a lot of reference to the guidelines, which are prepared by DDTC and give a very thorough and detailed guidance on how to prepare an application, the process for submitting an application, and what information is required when submitting an ITAR agreement application. And I think, while providing additional context here to point you in the right direction of different things to keep in mind, with any individual agreement, you'll want to, those guidelines will become your Bible, and you'll need to rely on them very carefully to ensure that you're hitting all of the steps and the requirements in preparing that application. So this just highlights some of the elements of an ITAR agreement. The Transmittal Letter, which is an executive summary of the proposed agreement, which includes specific information that's set forth in the ITAR and expanded upon in the guidelines. The proposed agreement itself, which would include any exhibits such as a statement of work, the description of the technical data that will be shared under the agreement, description of hardware that might be exported in connection with the agreement, or that's the focus of the agreement, sub-licensee information, and other items that may be relevant to the agreement. The DSP licensed vehicle is the electronic form that you use to transmit the proposed agreement to DTCL. And you'll use that system through D-Trade to upload the agreement application in its entirety. The certification letter is, which you can satisfy that simply by doing the electronic submission. And then you also have supporting documentation, which we'll discuss a little bit more detail later on in the presentation, but essentially anything else that's required in support of your agreement. So there are specific requirements for what needs to be included in your proposed agreement. Guidelines describe the requirements for proposed agreements in detail, and additionally, the regulations set forth some of those basic requirements that need to be included in any MLA, TAA, or WCA. And she must include specific information that's included in the ITAR and certain template statements that can't be modified. Your agreement should be reviewed by all the foreign parties and U.S. signatories prior to submitting the agreement application so that you can work out problems with language and details before you submit for review. The agreement, however, won't be executed until after you've received approval. And part of the reason for that is that DTCL may include provisos or essentially direct you to make changes or revisions to the agreement prior to its execution. So for TAAs and MLAs, there are certain information that needs to be included in any proposed agreement, including a description of the defense article to be manufactured and all defense articles that would be exported, including test and support equipment or advanced materials. A specific description of the assistance and technical data to be furnished and any manufacturing rights to be granted. One thing you really want to keep in mind is that you're only going to get authorization for information that's included in the agreement. So if there's technical data that you want to be able to share, you need to cover that within the agreement itself, or you'll be in the situation of having to submit amendments or apply for additional authorization. So you really want to understand the scope of your project as you're preparing that agreement so that you can be as inclusive as necessary. You want to include the duration of the agreement, the countries or areas in which the manufacturing, production, process sale will occur, and then include any required statements regarding to significant military equipment if those are applicable. Sorry, my clicker wasn't working. So for a WDA, some of the required information is, again, description of the defense articles involved, a detailed statement of the terms and conditions under which those articles will be exported and distributed, the duration, and the countries that comprise the distribution territory. So here you may have the warehouse located in one location with the intention to be distributing those articles in a wider area, and so you'll want to make sure that the agreement encompasses the full scope of that proposed distribution territory. And then there are several other additional items that need to be addressed in an agreement depending on the scope of your particular agreement, and we'll discuss those briefly further in the presentation as well, but those are foreign sub-licensing arrangements, transfers to foreign or dual or third country nationals, foreign person employees, non-regular contract employees, identification of end users, and additional transfer territories, and whether any brokering services will be provided in connection with the agreement. So here, the next few slides lay out a little bit more detail about those, the additional information that you may need to include in your agreement application. So with regard to foreign sub-licensing, you just want to keep in mind that sub-licensing is considered a re-export or re-transfer of defense articles or technical data by a foreign signatory to a third party that is not a signatory. By listing a foreign sub-licensee on your agreement, it does not authorize the direct transfer of defense articles or technical data or defense services between the U.S. party to the agreement and the sub-licensees. In other words, if you're directly engaging in the transfer of defense articles or technical data with a foreign party, then they will need to be listed as a signatory to the agreement, not a sub-licensee. The sub-licensee relationship is really reserved for the foreign party to the agreement needing to reserve the possibility of sharing technical data or defense articles with another foreign third party in connection with the agreement. It may not always be the case that they end up sharing technical data with that sub-licensee, but you'll want to make sure that you've included them in the scope of the agreement. And this just gives some detail about what you'll need to provide with regard to the sub-licensee. Additionally, you should keep in mind that foreign person employees of the U.S. entity need to be identified in the agreement if they'll have access to the technical data subject of the agreement. And I think one thing that's important to keep in mind here is that just by including him in the agreement is not the only step that may be necessary with regard to a foreign person employee. So you should keep in mind that you still have obligations with regard to licensing for the transfer of technical data to that individual employee. And with regard to contract employees, it's important to keep in mind that if a contract employee meets the definition in the ITAR of a regular employee, they can be treated within the scope of the U.S. person signatory to the agreement and don't need to be separately identified in the agreement itself. But depending on certain factors, it may be that that contract employee doesn't fit into the definition of regular employee and would need to either individually or by the contracting company be identified separately in the agreement itself. So for the purposes of an agreement, an end user is any party who will ultimately benefit from the transaction, ultimate recipient or user of the exported defense articles. That end user may be U.S. or foreign parties, but they need to be identified in Block 14 of the DSP-5 vehicle. They may receive defense articles, including technical data, but usually may not receive defense services unless they're also a foreign signatory. So I think one thing to point out there is the end user may not be the same as the foreign signatory, but both need to be identified on the agreement itself. So for transfer territories, if the transfers need to occur outside of the territories of the foreign signatories or sub-licensees, the additional countries where transfers will occur need to be identified in the agreement. So if technical discussions or meetings will take place in the country outside of the territory of the signatories, that needs to be disclosed and incorporated into the agreement. There's a couple details here with regard to brokering. I think one thing that's important to remember here is that while you have certain obligations to include information about brokering that will occur in the agreement itself, there are detailed regulations and requirements with regard to authorization for brokering activities. So even it's not enough simply to include in the agreement that brokering will occur in connection with the agreement, but you'll need to be cognizant of those additional requirements for brokering and be certain that you've also complied with those requirements. I think, compliance with one portion of the ITAR doesn't negate the need to comply with all the other provisions. So you may have dual notification obligations or licensing applications requirements in connection with brokering activities. And a few final considerations when preparing a proposed agreement. The use of collective language, which, for example, referring to NATO or the EU, is not authorized. You need to identify countries individually or distribution territories by individual country. And it's permissible to use law firms and consultants in assisting to prepare agreements, and in fact it's recommended, especially if you're new to ITAR. It's helpful to have some expertise from law firms to assist in the preparation of those agreements. And the requirements by DDTC is that any written correspondence still needs to be signed by an empowered official of the company. The submissions need to be made on your company's letterhead, and you should notify DDTC that the law firm or consultant is authorized to act on your behalf. Agreements in support of U.S. government operations can potentially be expedited, and we'll talk a little bit more about timing later, but one thing that's really important to keep in mind with that is if you're requesting expedited treatment because the agreements in support of U.S. government operations, you need to ensure that you actually meet all of the requirements for expedited handling of your review, because if you submit a request for expedited review and you do not meet those requirements, your application could be returned without action and cause additional delay in having to resubmit. And with regard to translation services, you just want to review the requirements to determine whether any additional licensing is required for utilizing a translation service, whether they'll have access to technical data or information in connection with providing those services, and so there's just be aware that there are specific requirements that should be reviewed. When you submit an application for review, you need to provide a transmittal letter, which, similar to the agreements themselves, has specific requirements for what needs to be included in that letter to help guide DDTC in the review of your application. MLAs and TAA transmittal letters need to contain information that's detailed in the ITAR in Section 124.12a. There are specific clauses that need to be included in the transmittal letter. And again, the guidelines provide significant detail on the form and contents of that letter. So you should always have the guidelines handy when you're preparing the agreement and review them in advance so that you know what information needs to be collected and included in the transmittal letter as well as the agreement. For the WDA, required information and special clauses are set forth in 124.14 E and F. And again, there are specific guidelines in Section 7.1 for submission of a transmittal letter for WDA. All requests for licenses, agreements, and amendments must be accompanied by an empowered official certification letter, which can be satisfied when you're submitting a DSP-5 vehicle in the certification statement in Block 22. So in certain circumstances, congressional notification is required in connection with an agreement application. The Department of State must provide a certification to Congress prior to approving a TAA or MLA for the manufacture of significant military equipment abroad, regardless of value, or the export of military defense equipment or defense articles or services above certain monetary thresholds, which are if there's any item of SME on the USML with a non-recurring research and development cost of more than $50 million or a total production cost of more than $200 million, then congressional notification is required. So there's some tips here on when congressional notification is required. The value thresholds vary based on the technology and country of export and the type of agreement, and there's guidelines for calculating the value that you would need to review. And because congressional notification involves additional steps, it's important to keep in mind that if congressional notification is required, it could prolong the amount of time necessary to review the agreement application and delay when approval could be received. So MLAs and TAAs that are related to significant military equipment or classified defense articles will require a non-transfer and use certificate in addition to the agreement that's signed by the applicant and the foreign party that will receive that, the SME or classified defense articles. For purposes of agreements involving classified articles, the DSP 83 must be signed by authorized representatives of the foreign government or accompanied with a diplomatic note. And the transfer may not occur before the DSP 83 has been submitted to DVTC. So even if you have an executed agreement in place, the DSP 83 is also required before any transfer. Another additional piece of information that may need to be included is a Part 130 statement, which are required if the value of the agreement involves the export, re-export, or retransfer of defense articles, technical data, or defense services valued at $500,000 or more that are being sold commercially to or for the use of the armed forces of a foreign country or international organization. And in those cases, the Part 130 requires the applicant to inform DTCL whether the applicant or its vendors have paid, offered, or agreed to pay a political contribution or fees, or certain fees or commissions over certain value thresholds, and the specific requirements for when those 130 statements are required or outlined in Part 130 of the ITAR. These are just a couple additional things to keep in mind when preparing agreement applications. The guidelines, as I've mentioned throughout, are an extremely useful tool in helping ensure that you've met you've included everything that you need to include in your transmittal letter, in the agreement itself, and provided all the supplementary material that's required for review. Specifically, some sections that provide some additional assistance that are really useful are Section 17, which is a good starting place before you're preparing to submit a package to review and ensure that you have all the required submissions, that you've got your transmittal letter, supplemental materials, and anything that's required with that agreement so that you don't have an RWA. Section 2.8 gives some common submission errors that the agency has seen, which can be helpful to avoid. So, for example, ensuring that you've identified the appropriate value of the agreement in Block 12, which could differ depending on whether you're submitting a new agreement or rebaseline, which we'll talk about in a bit, or an amendment to your agreement. Also important to remember to identify your foreign ultimate end users, which could be both foreign licensees and end users that are not identified as foreign licensees. And it ranges from some of the more complex common errors to simple things like making sure the company names you've listed in the DSP-5 vehicle match the company names that you have listed in the agreement. Section 18 gives some additional information and guidance and helpful hints for preparing information when you have a situation where technical security review is required by the Defense Technology Security Administration. Sorry, it gives additional hints as to how to explain technical information and describe the technical data that will be subject to the agreement so that it can be easily understood by the agency reviewing, conducting the technology security review. And Section 2.6 discusses processing timelines. I mentioned that briefly with regard to congressional notification, but it's important to keep in mind that it could take a significant amount of time to review and receive approval for an agreement application. You want to be aware of that as you're contemplating the project and preparing the agreement, that all the parties understand the amount of time that it could take to have an authorized agreement. Could be between 2 and 4 months, depending on whether the agreement needs to be reviewed by multiple agencies, or if there's a congressional notification requirement, or if there's additional national security review considerations. So once you have an approved agreement, there's additional ongoing obligations with regard to agreement management. You'll receive an approval from the DDTC via a DSP-V vehicle, but before exporting any technical data or defense services under the agreement, it needs to be fully executed. So I don't have that listed here. Maybe we'll talk about it later, but it needs to be executed by the parties, and you need to notify DDTC before any of the exports have begun. And then typically once that's approved and you have the executed agreement, you can provide those defense services described in the agreement without any further licensing. An approval will also come with a set of provisos from the Department of State, which are additional instructions to the agreement. There are some standard provisos that are included in an approval, but there also may be some that limit the scope of the originally proposed agreement or may direct the parties to incorporate certain changes before the agreement can be executed. Some of the more common provisos are the requirement to upload the signed agreement, which once it's been executed by the parties, the expiration date, which is typically 10 years for the agreement, and that there may be a separate licensing requirement for the export of any hardware in connection or in furtherance of or in support of the agreement itself. If you receive provisos that you believe are inappropriate or too restrictive, you can submit a proviso reconsideration request to reword the provisos. Those are considered a major amendment, which we'll talk about a little bit later as well, but they can be submitted in conjunction with another amendment to the agreement. And you can request changes to multiple provisos in one application. So once you have the executed agreement, you need to file a copy with DDTC no later than 30 days after it enters into force. The agreement is concluded or executed when all parties to the agreement have signed it. And if a decision is made ultimately not to conclude the agreement, even after approval, the U.S. applicant is obligated to notify DDTC within 60 days of the date of that decision. And if the agreement is not concluded within a year of the date of approval, then applicants must submit a report to BTCL summarizing the status of the agreement and continue to do so on an annual basis, so long as you haven't determined not to conclude the agreement or actually conclude it. Another obligation for ongoing management of the agreement is that for MLAs and WDAs, applicants must submit an annual report on the sale of manufactured or distributed hardware under the agreement. So some things to keep in mind with regard to the annual sales report is the first report request is for the year the agreement was executed. They can be submitted to cover calendar or fiscal years. And if it's not active in a particular year and no sales have occurred under the agreement, then you still need to submit a report to notify that no sales have occurred. So oftentimes the nature or scope or other aspects of the agreement may change over time, so there is a process in place to submit amendments to agreements. And once an amendment is approved by DTCL, any changes to the agreement must be made via an amendment, which changes to the scope of the agreement, modifications, upgrades, or extensions must be submitted for approval. The proposed amendment must be signed by all participating parties and serves as a medium for detailing the change. Major amendments must be submitted as entire agreements with proposed changes identified by bold, so bold text. So you resubmit the entire agreement with the new language included in bold, so it's easy to see where those changes have occurred. And follow the requirements set forth in ITAR sections 124.8 and 124.9. They'll also require a new transmittal letter. Again, there are specific agreements or guidelines set forth in both the ITAR and the guidelines addressing what information needs to be included in the transmittal letter when submitting a request for an amendment. Amendments can also include a request to extend the agreement and must be submitted at least 60 days before the agreement expires. So certain amendments to agreement are considered minor and do not require approval from DTCL in advance. However, after they're concluded and incorporated, you still need to notify the agency that the change has been made by submitting an updated agreement. So some examples of minor amendments are to correct typos or mistakes in the original submission, to correct an address. Certain name corrections can be considered minor amendments, or removing a sublicensee from an agreement. Additionally, for agreements that were authorized prior to 2009 and are considered legacy or paper agreements continue in effect, but whenever there is a need to make an amendment to that agreement, it's considered a rebaseline, and technically it becomes a new agreement. And so there are specific requirements for how that should be submitted and identified to DDTC. And again, there are guidelines walk you through what the transmittal letter and proposed agreement should reflect to indicate that that's a rebaseline application. When the U.S. party, or when an agreement is terminated, there also are notification requirements to DDTC. You must inform them in writing of the impending termination of an agreement at least 30 days prior to the expiration. And you must submit a final sales or activity report. I've noted here that you should communicate the intended termination to all the signatories of the party to ensure that there is no ongoing activity occurring under the agreement. It's important to keep in mind that if you notify DDTC that an agreement is going to be terminated on a certain date, any activity that occurs that was previously covered by that agreement after its termination could potentially constitute an export violation. So you want to make sure that all those parties are aware that that activity is not going to continue. So while ITAR agreements they provide authorization for the export of technical data and defense services in certain circumstances, which means that the additional export of defense articles or hardware in connection with those agreements likely requires additional licensing before you can make that export. So there's a couple of different circumstances where you may need to export hardware in connection with an approved agreement. So the two primary examples are exports of articles in furtherance of the agreement or IFO license, and exports of articles in support of an agreement or an ISO license. So IFO licenses are applicable when the hardware is included in the scope of the agreement. It's contemplated at the time of the agreement that you would be dealing in the specific hardware that you're now hoping to export. And there's a few additional requirements here. The end user must be a foreign licensee or an end user identified on the agreement. And you need to include specific support documentation, including your purchase order, letter of intent, contract, request for the goods, etc. And this gives some specifics on the value of the hardware exported in furtherance of an agreement. It can't exceed the value authorized by the proviso in the approval, and the method for decrementing value on the agreement differs for permanent and temporary exports. So you want to just review those requirements and make sure that you're calculating the value appropriately and decrementing the value with any exports in furtherance of the agreement appropriately. Here's a couple other examples for authorizations for IFO hardware exports. To repair or replace a defense article that was previously authorized for export. Any U.S. applicant can request a permanent export without a license as part of the agreement application, but that exemption is only available when specifically requested in the agreement, and all requirements of ITAR Section 123.16a are met. So licenses for the export of hardware in support of an agreement are slightly different in that the hardware doesn't need to have been identified or reflected in the scope of the agreement itself, but you do need to then include a statement that explains why the export of this hardware is in support of the agreement itself. So that they understand why this should be considered in connection with the agreement as opposed to being a standalone license. So there's a couple of slides here that just discuss how export control reform has impacted agreement requirements and management, and I don't want to go into too much detail about export control reform, but essentially as a result of export control reform, articles, defense articles may have been moved to different USML categories or even removed from the USML entirely and to the CCL, which is governed by the Bureau of Industry and Security. And so because of that shift, it may have an impact on agreements that are in place that identified technical data or even hardware under certain USML categories. And this is just a list of the status of some of those changes. So while most of the changes to USML categories have taken effect, there are still some that are forthcoming and could impact agreements that are currently in place that involve those articles. So ECR added a new paragraph X to all revised USML categories, which allows applicants to obtain authorization from DDTC to export hardware, software, and technical data that's now controlled under the EAR if the agreement also involves the export of USML-controlled hardware. If you need to make an amendment to an existing agreement to add paragraph X for transitioning items, you can do that via a minor amendment without submitting it for approval in advance. And again, this just gives some guidance on the effect of ECR on existing agreements, depending on how those changes impacted defense articles that are incorporated into your agreement. So specifically with regard to IFO license, existing agreements do not need to be amended to allow IFO license using new USML subcategories. IFO license may include paragraph X hardware if the license includes a proposed export of defense articles. You can't submit an IFO license application containing exclusively paragraph X hardware, and the re-export or retransfer of paragraph X items to end users or locations not approved in the agreement can be accomplished either by amending the agreement or seeking separate authorization from Commerce for the re-export or retransfer. So just some final thoughts on agreements in general is to keep in mind, know the law. Government authorizations required for all exports and re-exports of controlled goods, data, and services. Always review the regulations and the guidelines and other resources provided by DDTC on their website, because there's a plethora of information available there to help guide you in agreement preparation and the application process and management of the agreements once in place. And keep in mind that ITAR agreements are your authorization for sharing of technical data and providing defense services, and you still need to ensure that you have the appropriate licenses for the export of hardware and that you're complying with the other requirements of the ITAR with regard to brokering activities and other exports. And be prepared before you start the process of applying for an agreement. Really understand what the scope of your project is, the items that you're hoping to export, who the end users are, what the end use will be, and start collecting that information early and in sufficient detail so that you can prepare your agreement and not have an RWA. Also, in connection with that, ensure that you plan ahead, because as I mentioned previously, approval times for licenses and agreements can take a long time. So it can range from several weeks to several months, and it also takes time to prepare the application sufficiently, and you want to make sure that all parties involved understand the timeline and how that might affect project plans going forward. And with that, I can open it up to any questions that people may have.
Thanks, Tina. That was a great, really detailed presentation. Appreciate you sharing your expertise. For folks on the line, you can press *1 to record your name and then ask a question over the telephone. Again, that's *1 if you had a question. In the meantime, Dana, while we wait for any questions over the telephone that may come in, we did have a scenario come up during your presentation, and that is a U.S. company is exporting a dual-use commercial item classified as EAR 99 to a foreign military. The question is, under what circumstances is a TAA required for integration of the EAR 99 shipment with the foreign military system and or collaboration with the foreign military?
That's a good question. So I think one thing to keep in mind is there does have to be some connection to technical data or defense articles that would be covered under the ITAR. So if there's there may be circumstances where you can incorporate the transfer of items that are subject to the EAR into an agreement, but you have to be within the jurisdiction of the ITAR in the first instance. So I think you want to look at the specifics of the situation and see whether there's any reason to pursue a TAA, but simply sharing an EAR 99 item with the foreign military might not necessarily trigger those requirements.
Thanks, Dana, and we'll do our first check with the operator. Operator, have we had any questions come in over the queue?
No, ma'am. I'm showing no phone questions at this time, but again, a reminder to ask a question, press star 1.
And we just had another question come in over the written queue, and that is for reporting on ITAR shipments under an MLA export license. Do you need to specify the actual end customers or just the location that the items will be sent to in the U.S.?
Well, I would definitely have to go back and review the specific requirements, but my sense is typically that you need to identify the specific end users. But I can certainly review that and follow up with the requester separately as well.
Operator will do another check of the phone lines.
No, ma'am. I'm showing no questions.
Okay, we'll just wait a couple more seconds to see if anything else comes in.
Sure. And I will say, in addition to the last question, typically those details are going to be outlined in both the regulations and the guidance provided. So if it doesn't specifically state that an end user needs to be identified, then it probably is not required. There's not a lot of, I think the guidelines aim to remove ambiguity, and while I understand that's not always the case, I think if you can find, look to the guidance for the specific question that you have, and it should provide some fairly detailed explanation of what needs to be reported in a particular circumstance.
An operator will do one final check for phone questions.
And, ma'am, I'm showing no questions.
Great. Well, Dana, thank you so much again for sharing your time and your expertise this afternoon. Again, we'll be sending out a copy of the presentation later this afternoon. And as a reminder, our next webinar is this Thursday at 1 p.m. Eastern on deemed exports. So look forward to speaking with everyone then. Thanks again and have a good afternoon.
Great. Thank you.
Thank you. And this does conclude today's conference. All parties may disconnect.